online resolution has been provided by you to everyone's doorstep. So thank you so much. And
Thank you for the kind words.
yeah, and Mr. Shiv Kumar, his name is auspicious. I must tell you, Colin, his name is auspicious for us. It means Lord God Shiva for us in India. So someone who is an embodiment of kindness, grace, and dissolver of darkness. And I think these qualities a mediator should possess. So Mr. Shiv Kumar, our very dear senior mediator, is here to bless us with this. And he's been writing in last 3 editions theory papers, also articles on classroom series. He and Mr. Bharata Chakravarti are another senior mediator from India. Both of them are doing the writings also on the components of the Bar Council curriculum. And in fact, it was you only, Corin, that in October, when we started with this, your interview was there in our October edition of e-mediation writing when we launched Generation Next. So thank you again. And I thank everyone from our e-mediation writings team. We can see our dear friends on screen, students who are here. And please make just the best utilization of this moment, because we're going to commence this and we'll try to finish this course by April 2021. And I see that in future day is not far when we'll have a degree not just as Bachelor of Law, but it will be LLMB, Bachelor of Laws and Mediation. So it will be prescribed in colleges, because mediation, my dear student, it changes you as a person. It will change your outlook as a legal advisor to your clients, prospective clients, and it will change your way, the way you would be behaving in mediation as an advocate. So please make best utilization of this platform, and we are there with you for life. So God bless you all. So over to our dear friend, young moderator, Saharsh Pandey, who would be moderating the today's program. Thank you so much. Welcome all. Thank you.
Good morning, ladies and gentlemen. As ma'am has already introduced me, my name is Saharsh Pandey, and I'm a third-year law student at National Law University, Nagpur. Well, first and foremost, ladies and gents, today United Nations and other civil rights organizations are celebrating the International Volunteers Day. And for the purpose of our meet, I would give a huge round of applause and cheers to the respected organizers, honorary dignitaries, fellow members of the organizing committee, and other personnel attached with the event, so as to achieve the goal of academic pursuit even in such unprecedented times. Today, we all have gathered to commence the 3-month classroom series program on importance of mediation door to door, which has fortunately been preceded by the launch of our e-magazine at the behest of Mr. Colin Rule. Sir, we would like to extend our heartiest gratitude to you. Today's session is of about 1 hour. Initially, Mr. Colin Rule will be speaking for 20 minutes, followed by Mr. Shiv Kumar for about 20 minutes. And we are going to complete our session by a 15 minutes question and answer round at the end of the event. I would request the respected members to kindly mute themselves, and in case of any question, query, comment, or suggestion, they can kindly put so in the text box. Ladies and gentlemen, we also have posted a feedback form. We are going to post it in some time, which is also in the nature of an expression of interest for the potential candidates for the course. We are also going to post our contact details for further inquiry. So now coming to the event. So first speaker would be Mr. Colin Rule. So ladies and gentlemen, sir is the president and CEO of Mediate.com. I guess we all have heard about it at once or the other time in our lives. And sir has have experience of more than 25 years, ladies and gentlemen, in not only ADR, but also in ODR field. So that is a bit of a miracle for us. Sir is the author of Online Dispute Resolution for Business, one of the books that has its name in many of the accolades. Sir has also received many of the prizes, including the first Frank Sander Award for Innovation in ADR from the American Bar Association in 2020, and the Mary Parker Follett Award from the Association for Conflict Resolution in 2013. Sir is also currently co-chair of the advisory board at the National Center for Technology and Dispute Resolution at UMass Amherst. Sir, we would kindly request you to throw some light, give us a kind of a review over the importance of mediation in the current times, which has been reinforced through the COVID pandemic. Over to you, sir.
So Harsh, thank you so much for that lovely introduction. I really appreciate it. And hello, everyone. Thank you so much for having me here. It's a joy for me to see all your faces and be here with you. So thank you very much for making the time. If you don't mind, I'd like to share some PowerPoint slides because I think they will illuminate some of my remarks. So I'll keep everything to less than 20 minutes, and I'm very eager to hear your questions. So let me click share screen here. And then I will select my screen. So hopefully now you're seeing a screen that says ODR overview. Can I see a thumbs up if someone can see that? Okay, excellent.
Yes.
So I'll constrain my comments to a few slides because I'm very interested in hearing from the rest of you. I love this topic, mediation door to door. And I think I've had an opportunity to spend a fair amount of time in India and work with a lot of my Indian colleagues. One of my closest colleagues, maybe my closest colleague in the world, is Chittu Nagarajan, my co-founder at Modria.com. She's based in Chennai, and I work very closely with her to this day. We have talked weekly for now 15 years. And Chittu, I think, has been very involved in the evolution of online dispute resolution in India. And she's taught me a lot about the need for mediation in India. I've also worked very closely with CAMP in Bangalore, the mediation program. And my understanding is that when you file a civil case in India, the time from filing to an actual hearing in front of a judge can be as long as 10 years. Which is amazing to me. There is a huge backlog of cases in India that need to be resolved. And that should be a call to arms for all of us in the mediation field. The need for dispute resolution in India is protracted. And that's why we must all embrace our role and step up to help India deal with this backlog and move into the next generation. So I think it's very clear, if this is true anywhere in the world, it is true in India. Society is moving online. The expansion of broadband internet, mobile devices, social networks, and now video conferencing is not only quick, it is inevitable. And I think the pandemic has definitely accelerated all of these trends. So if you are not online, if your services are not available to people online, you risk becoming increasingly irrelevant. And I think what we see is the courts are not built to innovate. So they are not able to make this transition to the online world, but we in the dispute resolution field are. And online dispute resolution is the use of information and communications technology to help people resolve their disputes. But even more broader than this, online dispute resolution is also about preventing disputes from arising in the first place and also managing disputes that are not ripe for resolution. So it is an extension of face-to-face mediation. Online dispute resolution is dispute resolution plus technology. That's fundamentally what online dispute resolution is. And if you push me, I would even say that ODR is just the future of ADR. As our society moves online, all ADR will become ODR, and that's what we've seen with the pandemic. So another definition of ODR has been promulgated by the National Center for State Courts in the United States. The courts think about online dispute resolution a little bit differently than those of us who are mediators. And they say that ODR is a public-facing digital space in which parties can convene to resolve their dispute or case. And I think we're getting much more specific about our definition of ODR as ODR becomes more prominent across the world. So let me talk about all the different types of ODR processes. Now, of course, we're focused on mediation today, and there are a lot of things that technology can do to give new capabilities to mediators and make mediators more efficient. But ODR also embraces evaluative mechanisms. Note, I did not say arbitration, I said evaluation, because there are ways to provide evaluative outcomes through ODR that are not traditional arbitrations. But we also have the ability to provide technology facilitated negotiation and problem diagnosis. So we can even work with a complainant on their issue before they notify the respondent that they have a concern. So initially we thought that ODR would just be exactly like face-to-face dispute resolution, but brought online. But we've learned that there's new capabilities that online dispute resolution brings to the table. And it's opened up new possibilities for how we can work with parties. Now, I was the director of online dispute resolution at eBay and PayPal. And we actually built a piece of software at eBay called the Resolution Center. It resolves 60 million disputes per year, which is more than the US civil court system. It worked in 16 different languages all over the world. And 90% of those resolutions happened in software only, meaning there was no human intervention. It was just the disputants, party A and party B, working with a software algorithm. And I think what happened was when we proved that we could resolve billions of disputes through this mechanism, we very quickly started to get interest in ODR in other dispute categories, like other e-commerce sites, like Airbnb has host and guest disputes instead of buyer-seller disputes. You have companies like Lyft that have rider-passenger disputes. So every e-commerce site, every collaborative economy company, they have disputes. But there's also offline consumer disputes. And then we start to get into things like property tax appeals or insurance disputes or product liability cases. We spun out the technology from eBay and we started to tackle all of these other verticals, but inevitably we were brought into the courts, and now online dispute resolution is being integrated into the court flows themselves, and we can talk about exactly what that looks like. So now what we see over the last 20 years is online dispute resolution has been applied to millions and millions, even more than 1 billion disputes per year all around the world. We see courts being launched that leverage online dispute resolution techniques in the UK, in Canada, in China. The European Union has created a regulation that requires that ODR be made available to all consumers in the European Union. UNCITRAL, which is the UN agency responsible for harmonizing global laws, they've passed a recommendation around cross-border resolutions. So we're seeing ODR explode around the world at an increasing rate. But what I'm most excited about, actually, this is the UNCITRAL technical note that was adopted by the General Assembly calling for an expansion in the availability of online dispute resolution. And I think this is why the European Union launched its ODR regulation, because UNCITRAL had created a framework for how these systems could work. That also led inevitably to APEC, which is the treaty organization for all the countries that ring the Pacific, that are now using ODR to build a resolution process for small and medium-sized businesses to resolve cross-border disputes. And we also now have the International Standards Organization that is promoting ODR for high-volume, low-value cross-border transactions. So we see a lot of international organizations advancing ODR. But the one I'm most excited about is India. I think India is the most exciting geography for online dispute resolution right now. And obviously, the Modi government has announced that they're going to be digitizing payments in India. And they've even outlawed certain denominations of currency to urge those transactions to move online. A good friend of mine, when I worked at PayPal, Upasna, she started MobiKwik, which some of you might have heard of, which is an online payments company. But there's MobiKwik and there's Paytm and there's other digital payments companies. And Chitu has told me that, again, if you go buy some fruit off of a cart in the street, you'll probably pay for it online through a digital application. So what the National Payments Corporation of India has announced, that online dispute resolution will soon be mandatory for online payments. And we see a rush of companies moving into this space to provide ODR for those digital payments. So the resolutions for disputes that arise out of digital payments will be built into the very infrastructure where those payments are taking place. And, with more than 1 billion citizens in India, I think this will very soon be the most active, highest volume geography for online dispute resolution cases. And this is going to be happening in the next year or two. So the point that I would like to make is we need to design these ODR processes in a creative way to ensure that they live up to the ethical obligations we have as mediators. It's not hard to see how someone might build an online dispute resolution process that is unethical, or maybe doesn't live up to the ethical guidelines we have for the work that we do. So when I think about ODR, I think about this modular approach where you have diagnosis, negotiation, mediation, evaluation. And it's almost like a staircase. If you can resolve the problem in diagnosis, great. You don't need to move on to the other phases. But the key thing is diagnosis and negotiation is software only. Mediation and evaluation, those are human-powered phases. So you want to resolve the disputes as early as you possibly can. So just to briefly talk to each of these, diagnosis is a phase where you use technology to set expectations for the parties around the online dispute resolution process, compiling the case file, collecting data from the parties, and delivering an automated resolution if appropriate. Negotiation, obviously, is where the two parties are communicating directly to find a mutually agreed upon resolution. And they may need to share evidence. They may need to make settlement offers. They may need to draft agreement terms, but software can structure that negotiation to make it more effective. Mediation is obviously what we're all experts in. It's where a third party joins the negotiation and assists the negotiators in trying to reach a mutually agreed upon solution. But there are a lot of things that technology can do to make mediation more efficient, including asynchronous interaction, text-based interaction, enabling caucuses to occur at the same time as the joint session, and also consulting a library of solutions that were achieved for similar types of cases. That can be incredibly powerful. So there are many ways that technology can make mediation more effective. And then evaluation, which can include arbitration. But there are other ways to provide evaluative outcomes that are not necessarily enforceable in the court, but that I think do an excellent job in providing closure in 100% of cases. So I'm not going to spend too much time talking about these ethical scenarios and ethical standards we have for ODR, but we've created an international nonprofit called ICODR, the International Council for Online Dispute Resolution, that is promoting ethical standards for online dispute resolution. And you can go to icodr.org and you can review these standards. But I think it's very important that all mediators be trained in online dispute resolution, because as I said, the online world is the future of dispute resolution, and understanding these ethical standards can enable you to be more effective as a mediator. So there's only one last point that I'll make before I hand it back. I do want to talk about the fourth party, and this is a key theoretical concept we have in the online dispute resolution world. We know that party 1 and party 2 are the disputants, and then party 3 is the human neutral, the mediator or the arbitrator. We think about technology as the fourth party, and the fourth party is getting smarter all the time. We currently ask the fourth party to do a lot of things to help us out in our mediation processes. They intake the cases, they process payments, they administer them, they send out notifications. Software also manages our documents and manages our calendars. There's a lot of things that technology can do today already to help a dispute resolution process. But the real question is what's coming tomorrow? As technology becomes more capable and more competent, and we start to leverage artificial intelligence and machine learning, I think technology is going to be able to help us with case research. It's going to help us understand and evaluate our cases to see the ZOPA, the zone of potential agreement. It's going to coach us in our cases. It will help us reframe our understanding of what outcomes are possible and understand our best alternative to a negotiated agreement. It may even automatically enforce our outcomes, but it can help us draft our settlement documents and submit them potentially to the courts, and even automatically negotiate our cases with the other side to try and maximize the Pareto optimality of the resolution that we achieve, to ensure it maximizes the value to both parties. So the last slide I'm going to show is this one. I think my grandfather always used to say to me when I was growing up back in Texas, he would say, Colin, don't build your business where the highway is, build your business where the highway is going. And I want all of you to think about where technology is going to lead us. It's fine to build services that work for the world as it is today, but it's a little bit more of a challenge to build dispute resolution services and platforms that work for the way the world is going to be tomorrow. And there are many companies and initiatives out there that are experimenting with it, with cutting edge technology, be that smart contracts or blockchain or artificial intelligence. But this notion of a new justice system based on dispute resolution that is completely decentralized, it doesn't rely on the coercive power of the state for its enforcement. It can rely on algorithms, and it doesn't depend on jurisdiction and local laws. We can make an agreement in negotiation or mediation, and we can draft that agreement as a smart contract, and we can place it on the blockchain so that it can never be altered. And that smart contract actually can self-administer. This is a radical notion of how the justice system may evolve in the internet age. And we in the online dispute resolution field, we have the expertise and the knowledge to build this system much more effectively than the judges and the lawyers who are wedded to the ways of the past. We don't want to just use technology to pave the cow paths. We want to make sure that we can build a new system that works the way the internet works. And I think this is an enormous opportunity for us to expand access to justice and provide fast and fair resolutions using the tools that we know so well as dispute resolvers. So I will leave it there, and maybe we can come back and have some further discussion, but hopefully I planted some seeds for further thought. So thank you very much for the time.
Thank you so much, sir, for your valuable insight. It was truly enriching for all of us. Further, I would like to invite Mr. Shiv Kumar for taking over to the floor. Sir is a senior advocate with 40 years of active practice at the Karnataka High Court. Sir is a designated master trainer at the BMC. Sir has also completed the 40 years commercial mediation course offered by the Ministry of Corporate Affairs with distinction. Sir has also completed the advanced training in commercial mediation conducted by the United States Commerce Department. Further, I would like to invite sir to take over the floor. Over to you, sir.
Thank you, Colin. That was brilliant. I think you put all of us on, succeeded in making all of us feel completely irrelevant as of now. We at my age of 70 and odd, to even think of technology as a means of dispute resolution is to fight an unknown enemy. We belong, I at least belong to the paper and pen generation, where every thought, every process was penned down on paper, converted into drafts, and there so on and so forth. But I do quite see what you're trying to get across to us. The technology will rule the day-to-day, and therefore will also rule the dispute resolution process. I will begin with, I'm sure you're aware of it, but bringing to your notice that the Niti Udyog, which is the planning authority for the government, has released a preliminary report on the future of ODR in India. And they make a very interesting distinction. They make a distinction between ODR and EADR. Now, they believe that ODR is a larger definition which will take into account artificial intelligence, machine learning, where the process itself is used to resolve disputes without human intervention at all. That is the distinction they're trying to make. And the current online dispute resolution mechanisms that we are using today, they classify it as EADRs, that is electronic alternate dispute resolution mechanisms, where we use video conferencing, so on and so forth. Now, whether this is a distinction without a difference or whether it really makes any kind of material difference in understanding ODR or ADR is a matter of debate. But the process is in motion right now. We have submitted our objections and our comments to the initial report. Let's see where we go from there. But they do recognize every one of the points that you have made, that ADR ODR seems to be the future for dispute resolution, thereby possibly rendering the court system redundant. An interesting point was raised some time ago in a conference in Bangalore by Justice Thakur when we were talking about the influence of ODR and artificial intelligence. The question is where discretion is vested in a judicial authority. For example, in a magistrate who has the discretion to impose a sentence of 5 years imprisonment or 2 years imprisonment or impose a fine or both, then how does ODR function? How will AI function? How will machine learning function? Because discretion is a matter of individual choice. And that question was left open because nobody seemed to have an answer. Wherever discretion is vested, how does machine learning exercise that discretion? And therefore, this is one of the areas of difficulty that we will face when we move into a total phase, if we do move into a total phase of replacing justice delivery systems and alternate justice delivery systems by ODR methods. That's a matter of debate and a matter of discussion. I would start with that. Now, we need to understand this resolve and reform are the two keywords that are placed today for some kind of a discussion. My question to all the students and to everybody on the screen is, what do I resolve? What do we resolve? What do we need to resolve? What do we need to reform? Whom do I need to reform? And why do I need to reform? Does mediation actually address all these issues? Does the ODR platform address all these issues? Or does the ODR form of dispute resolution presume that there is an intent to resolve? Any dispute resolution process can move forward, be it online or be it otherwise, only when there is an intent and a desire to resolve. Now, how do we create that? Can machine learning replace that? Can ODR methods create that environment among litigants where you inculcate in them the idea that we need to resolve it through alternate dispute resolution mechanisms and not go back to the traditional system? Where does technology stand there? See, ODR steps in only after the basic hurdle of my being agreeable to resolve it through ADR arises. How do we inculcate that? Can a machine do that? Can an artificial learning do that? Or can statistics do that? Or can statute do that? There is a question that needs to be debated upon by the students. I don't want to answer that question, though there are multiple answers. Let's see where this question takes us. Then the question of reform, door-to-door reform, the window of opportunity to reform. Reform what? Reform whom? Are we therefore venturing into the area of transformational mediation from the facilitative mediation that we are constantly talking about? Are we going to give importance to transforming the mental state of litigants in this country or mental state of people who agree to participate in mediation? If so, how is that to be achieved? See, once we are at a level where disputants agree that they want to resolve outside of the traditional judicial adversarial system, once the disputants come into the mediation process saying that I want to reform my thinking process, I want to reconsider the manner in which I'm approaching this dispute, then technology can step in and aid that process. It's a tool. It is not an end in itself. ODR is only a tool. It eases the methodology. It gives you a platform which is more easily accessible to resolve a dispute. But to get parties to that state of mind, who is responsible? Who does that? How do we achieve that status? This is a question that has been bugging us for a long time because I do a lot of private mediation. And I have found that the first hurdle in convincing disputants that ADR, alternate dispute resolution, forget ODR, ADR, be it mediation, be it conciliation, be it arbitration, is equally effective in dispute resolution is the first hurdle that we are unable to cross. We can't use technology. Technology is a tool. I can convince them to say that you don't need to come physically to the mediation center or to a mediation room or to the court. I will assist you in doing what you want to achieve through technology. But how do you convince people, both the parties, that I need to adopt ADR rather than the regular process? This is one of the greatest challenges that we are facing and we will continue to face. If we can find an answer to that, you will be easing the process of the mediation process. Now let's move on to something else that has been bothering me for a long time. We talked about ODR. ODR simply means online dispute resolution. It could include arbitration also. It necessarily does not exclude arbitration. It includes conciliation, facilitation, so on and so forth. Under the Indian Arbitration Act today, we have a provision, which is Section 29B, which talks about fast track arbitration, which provides and enables both the parties to simply submit whatever documentation they have, whatever arguments they have, whatever claims they have to an arbitrator, and dispenses with the need for oral evidence and for personal appearance of the parties. If the arbitrator feels that there is a necessity to get clarifications, it is his discretion to call upon the parties and have a conversation with them. But otherwise, it's fast track arbitration under 29B. Do you know that nobody uses that? Can you find a better place where ODR can be used? Where fast track arbitration can be done by simply submitting documents online and an arbitrator submitting an award based on those documents and the evidence. Now, that is a place where online dispute resolution will prove to be of immense value, because the time for arbitration will be reduced to probably 30 days or 20 days. Parties can sit in their respective locations and upload documentation that is required, and the arbitrator takes a view or decides and passes an award on the basis of that. Yes, in those cases where parties submit themselves to such an ODR methodology or an ADR methodology, technology is going to be helpful. But if I have to convince somebody that you try this, then there is an issue. Now, take, for example, we have, this is especially for your consideration, Colin. We have online, we have court annex mediation. I'm sure when you worked with CAMP and other places, and in fact, the Bangalore Mediation Center is primarily for court annex mediation. Technically, we have given to the parties the right to decide whether they want to go into the mediation process or not go into the mediation process. But superimposed on this is the power of the court to compulsorily refer you to mediation. Now, once you have these contradictory provisions in law, how and why would we expect parties or litigants to either seek resolution through ADR, or to reform their thinking to accept mediation as an alternative dispute resolution process? So I would, while agreeing with whatever you have said so far, I would like to focus all the students' attention here and others' attention also to see how we can cross this fundamental barrier of the human resistance to change. Human mind will resist anything that is new. That is a problem with andragogy. That is a problem with adult learning. I'm sure all of you are aware of it. So can we address that issue before we look at ODR as a means of resolution? It's a fabulous way of resolution. There's no question about it. But after you cross the hurdle, that basic threshold, how do we cross? I will, 2 more minutes, then I will stop. The question that I would also raise on when you talk about ODR, as pointed out by Colin, was, has the time come to move from facilitative mediation to evaluative mediation? Have we reached that stage? Or are we still dependent on what do we call the age-old traditions? There is a word for it. I'm not getting it now. The kind of mediators that are expected to stick to those lines of being facilitative all the time, never crossing the line, and so on and so forth. We have been trained in that kind of mediation. Therefore, has the time come to move to evaluative? If so, how? Does that require reformation? Do mediators require to be trained in the art of, for example, making a mediator's proposal, which is banned today? Whereas today, if you get into the mode of conciliation, a conciliator who is not even a trained mediator is allowed to make a proposal that is contained in the Arbitration and Conciliation Act in Part 3 of the Arbitration Act. So can you imagine the scenario where there are no qualifications for a person to be appointed a conciliator for a dispute? Anybody can be a conciliator, whereas a mediator requires to be trained. But a trained mediator is not permitted to make a proposal, whereas an untrained person who acts as a conciliator is allowed to make a proposal for the parties to consider. There is this dichotomy which we are facing today. There is a very minimal difference between conciliation and mediation today. So the question I'm raising for discussion is, have we come to a stage where we need a fresh set of mediators who understand technology, who understand the nuances of technology, and at the same time have the ability to be non-judgmental and yet to move towards a proposal for resolution of disputes? It's a very strange combination. These are opposing principles that we are trying to harmonize. So maybe that is a discussion that we need to talk about, whether we move into transformational mediation or evaluative mediation is something that we need to discuss. I believe that the interactive sessions are always a better way of learning rather than the top-down method. And I don't even know whether I've made any sense at all. But these are my thoughts. And I have been grappling with these thoughts for a very, very long time. So I will leave it at that and let's see where we go in terms of the discussions. Thank you very much.
Thank you so much, sir, for your kind insight. It was really a critical perspective that is indeed imperative for all of us to ponder upon as to what exactly is that we make out of the system. Now, I would like to open the floor to the respected members of the meet, the attendees, as to the question and answers that they would like to ask to our dignitaries. So the floor is open to you, attendees. If you have any question, comment, any type of a query or suggestion that you would like to ask, you may go ahead.
Could I intervene here, Pushp, for a minute?
Yes, sir. Please, sir.
In all webinars and conferences of this kind, participants are very reluctant to open up because they begin to feel that they may say the wrong thing. Please understand, guys, there is no such thing as the wrong thing. It is possible that both Colin and I have said wrong things, though I don't expect Colin to have said that. He's too far an intellectual for that. It's possible that this Shiv Kumar sitting here, who always takes contrarian views, is capable of having said wrong thing. Don't feel constricted by the fact that you're on a platform where you could say the wrong things. Please just go ahead, share your thoughts. When you share thoughts, that's when we too get inspired to say something different. Please just go ahead, say what you wish to.
I will piggyback on Mr. Shiv Kumar's comments
they're
as
very
well.
Disciplined.
That's good. I'm impressed with their discipline. First of all, I want to say, Mr. Shiv Kumar, thank you very much for your remarks. They deeply resonated with me, many of your observations. When I first started doing this work in the early 90s, the very notion of evaluative mediation was an oxymoron. The notion of a mediation process where the mediator would somehow judge the positions of the parties, that was anathema. Also, the notion of mandatory mediation. How can you have a mandatory voluntary process? It was inconceivable. And now those concepts are commonplace. Not only that, empirical research has demonstrated that mandatory mediation is very effective. So the court compelling parties to try mediation before they get in front of a judge, we see countries around the world embracing that, from Italy to Brazil. So I think your comments really resonate with me. Our understanding of mediation evolves, and that's a good thing. It's a good thing for us to constantly be questioning the tenets of our practice and then being open, particularly to younger practitioners, when they come in and they question some of the pieties I think that we have in the field. So please, I not only do I want to echo Mr. Shiv Kumar's comments, I want to say I welcome responses where maybe you disagree with something that I said or what Mr. Shiv Kumar said. That's not disrespectful. In fact, I appreciate the courage behind those comments even more. So please don't be shy. I see a comment in the chat. I don't know if you can see it, Mr. Shiv Kumar, from Nisar.
Saharsh, we have a comment in chat box. If you can take it, please.
What if the AI takes over human capabilities and then we, as a smart and brainy professionals, are not required at all? And how would Colin, that's for you. You are the smart and brainy person. I am the dead brain. So go ahead.
Nisarg, I think you, as we say in the United States, you hit the nail on the head. I think a lot of mediators see a presentation from my perspective, and say, "Wait a minute, what about me?" And if there's one thing that I can say to reassure you, is that I think as dispute resolution becomes more and more the default, as we say about ODR, there's no A in ODR. ODR is not an alternative. It becomes the new default. And I think when we talk about the third party and the fourth party will never replace the third party, because the third parties can deal with the psychological journey of the disputants. They can engage in active listening. They can engage in reframing. They can support the justice journey that parties have to go through to get to the point where they can embrace and accept the resolution. An algorithm will never be able to do that, no matter how many millions of records it can consider and how insightful its final outcome that it spits out may be. We will always need the third parties. So I think demand for mediation and arbitration is going to skyrocket in this new generation. I would be more worried if I was a judge or if I was a lawyer, because I think that these alternatives are going to enable individuals to resolve their cases before they have to resort to the courts. But I think mediators are actually going to see a big spike in demand for our services. So excellent question. That's my perspective. Mr. Shiv Kumar, do you agree or disagree?
Yes.
Please.
No. I dare not disagree with Colin. How would I? That's oxymoron. Anyway, this question I think is from Nisarg Desai. I would expect that he is either a student of law or just getting into practice. Am I right, Mr. Desai?
Yes, sir. I'm a final year.
There you are. So that explains the apprehensions, Colin. He's going to step into the profession. And if he says, I become redundant and irrelevant, who is going to feed my family and how am I going to pay for my scotch that I drink in the evening? That is the worry. Let me take this on a slightly different footing, Nisarg. When before the criminal law was amended, for example, where in economic offenses also, the prosecution had to prove that the accused was guilty. There was a kind of practice, a kind of approach to those cases that lawyers developed. The law was amended and said that the accused is presumed to be guilty and he has to prove his innocence in economic offenses. There was a complete paradigm shift where the onus and the burden of proof shifted from the prosecution to the accused. Did not lawyers change their approach? Did not lawyers acquire new skills, new methodologies, new thinking processes, and attune themselves to the change in law? So therefore, whenever there is a change in the system or the law, there is bound to be a change, and the human mind has the ability to adapt itself to that. Take the case of mediation itself. In the initial stages when mediation was introduced in this country in the year 2004 or 2007, I as a trainer have gone around all the districts trying to convince the district lawyers and practitioners that it would not affect their earnings. This was the question that has been thrown at us from the year 2007. You are hitting on our earnings. Your mediation will eat into our earnings. But over a period of time, what has happened today? Advocates who willingly come and participate in the mediation process are getting double or triple of the fees that they were getting earlier. Why? Because the time lag is reduced to 60 days. So there is something now, a subject called mediation advocacy. In fact, Camp at Bangalore runs programs on mediation advocacy. So the style of advocacy changes. The method that you approach the problem changes. The angle at which you look at it changes. You will evaluate as a lawyer, is litigation going to get me more benefits or will mediation get me a little better benefit? So this is quite normal. The worry is quite normal. Insofar as the AI taking over, Colin has already answered you, AI can never replace the human being. On the contrary, my worry is that judges will simply sit back and press a button and say the computer will deliver the judgment and not I. I mean, I'm scared. I'm scared that will happen where the qualifications, the mental requirements or the capacity or the erudition of a judge may be diluted so much that your competence will be to access the judgments or the AI or the computer rather than exercising your brains. I'm a cynic. That is what worries me more than lawyers. Lawyers need not worry. You will change, your practice will change. Today, pre-litigation mediation, Mr. What's his name? Where is he gone? Mr. Desai, pre-litigation mediation has developed, which means lawyers even before going to a court of law, come for resolution. Practice has changed, approach has changed, the attitudes have changed. So don't worry about it. You will get your bread, you will get your jam, and you will get your scotch. Provided, as Colin pointed out, you have ethical standards in practice of mediation. And I don't know.
As long as we get our scotch, I think that's what matters the most. I will say one last comment that I will make is it's not that we don't know what the impact of technology on law will look like, because we've already seen other industries that have been transformed by technology. For instance, look at finance. In finance, there used to be people whose jobs were to stand on the floor of the stock exchange and wave pieces of paper and say, who wants to buy 1,000 shares of this company or that company? Who wants to buy 10,000, pork bellies? That was their job. And now all of those people have lost those jobs. Those jobs are gone because those trades are now conducted by computers. And the floors of stock exchanges around the world are now quiet because computers are enacting these trades in milliseconds. So yes, those people lost their jobs. But now, today, more people work in finance than ever before. And what's happening is the jobs in finance are programming the computers that are doing the trades. And that is what is coming for the law. There is going to be a billionaire in online dispute resolution. I guarantee that there will be a billionaire in online dispute resolution. The problem is we don't know when, and we don't know who. That person could be in 3rd grade in Bangalore right now, and that's great because we don't know the future. But the reality is, if you see these changes coming, and you can anticipate these changes and evolve your practice to benefit from these changes, I think there is enormous opportunity. But if you ignore these changes and you just close your eyes and cover your ears and say, I'm going to do things the way they've always been done, I think that will not end up very, very well for you. The only constant is change. And that's, I think, what Mr. Shiv Kumar is saying. We need to embrace that change. And if you embrace the change, I think there's enormous opportunity. But if you ignore the change and you say, I'm just going to do things the way we've always done it, you're going to increasingly be left behind by the rapid pace of wider technological adoption within society.
Push one question. Colin, we know who. We have identified the who. He's on the screen right now. You.
Oh, no. My days are long gone.
All right.
Look at my gray hair. It's all done. I think my money is on Nisarg Desai. I think that may be the billionaire on the call. Much more like
one observation, Colin, I'd like to make. I opened my comment by saying that at 72, I've embraced technology. I was a paper pen guy. And I think she's hit the nail on the head. You don't want to embrace technology, no problem. Adopt the Hindu philosophy of saying, I'm happy with what I've got. That's what Hindu philosophy says. What you get, learn to be happy with. But
definitely, sir.
That's right. But if you embrace the change, then the sky's the limit.
Sir, if you can take, there are 2-3 questions. If we can quickly take down those also.
Please. Let's do it. Yes.
May I just take a moment or so?
Go ahead,
Yes.
you're the boss, yeah? You hold the
Yes,
floor.
sir. Go ahead, Sir. Take the questions.
So thank you, Mr. Colin Rule, and thank you, Mr. Shiv Kumar, for a wonderful answer. And I'd like to say that we all must be adaptive to the changes that society brings to us, because it's a two-way street. And definitely, I'm just a 22-year-old guy. I'm adaptive to the changes, but I need to understand every aspect of adapting it, that afterwards what is going to happen to brainy people like us. And I would also like to say that I hope that everyone adapting this ODR method become billionaire, but after me being a billionaire. Thank you, sir. Thank you very much.
I share your wish, my friend.
Sir, just pick up 2-3 questions from the chat box, please.
No, there is one for Colin directly. Let me do that.
Yes.
Colin,
It's
there is a
from Rohit
question for
Khare.
you. It says from Kavita Bhatia. She says, my question to Colin, sir. In second last slide, what's the fourth party? In ADR, generally we consider 3 parties. Maybe you need to go back to the slide if you can.
Absolutely. I don't need to go back to the slide. I will clarify. In online dispute resolution, the fourth party is what we call technology. It's almost like a robot is sitting at the table with you. Party 1 and party 2 are the disputants. Party 3 is the human mediator or arbitrator. The fourth party is technology. And that technology, as I said, you can envision it as a robot, but it may also be a voice that you say, Alexa or Siri or Cortana, and then it responds to you. Or it may, in fact, just be a computer algorithm that is running in the cloud. But that's what we mean by the fourth party. It's a way of thinking about the role of technology in the dispute resolution process as occupying an additional seat in addition to the human neutral and then the parties. That's what we mean. So excellent question, Kavita.
Yeah.
Yes,
Serge,
we have
there's
another-
one from, yes, there's another
Yes,
one
ma'am.
from Rohit also, and there are others also. Please take
Yes,
it.
ma'am. Yes, ma'am. Ma'am, sir, there is this question that in mediation, confidentiality plays a crucial role for its success. In the physical world, we have rules and laws to bolster the same. However, in ODR, individual platforms have individual confidentiality rules. And Ms. Ritansha Singhal has studied such instances where the data from one ODR platform was made public for promotional activities or to show it as a precedent in some matters. So, ma'am is asking that don't you think that ODR, though with enormous potential, but is actually disturbing the very essence of the mediation world, which is being confidentiality?
Absolutely. Why don't I'll take a swing at this answer, and then we can go to Mr. Shivkumar. I think technology is changing expectations around confidentiality. When I worked at eBay and PayPal, my disputants were eager to shout about their dispute from the rooftops. The expectation within the culture of eBay was not that the details of the dispute would be kept confidential. So I think what's important is that we set expectations for parties when they enter a dispute resolution process, and we make clear to them whether or not the process is going to be 100% confidential or whether or not there's going to be some information gleaned. Now, it may be that the personally identifiable information that's shared between the parties, that's kept confidential, but the outcome may be shared publicly. Or it may be that the parties are not sworn to confidentiality. They don't share the information from the mediation, but afterwards they have the right to talk about the outcome and share their perspectives. So I think that this is an evolving norm. You know, we have in the iCoder ethical standards, we have confidentiality, but we also have privacy, and we also have information security, and we also have transparency. And many of those things can be perceived as being in tension with one another. So we need to make sure that when we design our dispute systems, we're crystal clear with the participants around what information we will collect and who will get access to that information. And if we decide to build a dispute resolution process that has 100% transparency, like the ICANN domain name disputes process, where you see the actual names and all of the communications between the parties, it's all made public. That there are reasons why that kind of transparency might be a good design choice, but not for all types of disputes. Some other things like medical cases, we may say confidentiality is very important. So for me, it gets down to dispute systems design. How do we fit the forum to the fuss? And some ODR processes will be 100% confidential, and some may have a little bit more visibility and transparency to the outside. But we just have to be clear with the parties so that we set their expectations up front before they begin.
Thank you so much, sir.
Sir, there's Subhish. I think Subhish has raised his hand.
Just
If
a
you
minute,
can
I know I like to talk, so, but please give me 2 minutes. Colin, you're right. We have a very peculiar problem in the Indian context. I'm bringing this to you, notwithstanding technology. For example, under the rules prevalent in India today, copies of testamentary documents, the wills, for example, which are registered with the jurisdictional registrar's offices are confidential. They are not expected to be given to anybody except the legal heirs, that too on proof of death of the person or the testator who has made it. This is the rule in force. But the system in India, which allows for a variety of incentives to be given to the concerned authority, makes this copy available. Therefore, the question, particularly in the Indian context, we love prying on other people's confidential information. We love it. Who doesn't? And therefore, the system is so weak that it is the confidential information is accessible at a given price or at a given cost or through a given illegal or legal process. So you're right that when we do design systems for the Indian context, there has to be a 3 or 4 tier level of confidentiality that is required. That's a design. Secondly, when this question of confidentiality has been raised, that what is the methodology for preserving confidentiality? My counter question to is this: when we go into the mediation process and physically the mediator assures you that he or she will preserve the confidentiality of the information given, where is the monitoring mechanism or the controlling mechanism to ensure that the mediator does not disclose that? It's a question of trust. Now, I as a mediator assure you in the opening statement that I will preserve confidentiality. Whatever you say is not going to be disclosed without your express permission and so on and so forth. Done. But is there a post-mediation mechanism that prevents me or controls me or monitors me from disclosing it? It's the same level of risk that is transformed into technology. That's all I'm saying. It is the same. If I, as a mediator, disclose to Colin, this is what happened in my mediation, I have breached confidentiality. There is nobody who can control. Now, in technology, if I access this confidential information, the same risk. So I agree there is an issue. We need to address it. But it is nothing that has to create a scare. I mean, we give parties, I'm sure, Colin, you agree with me that when we start the mediation process, we advise the parties that they're free to disclose whatever information they wish to disclose. We also tell them that confidential information may be disclosed either joint sessions or in the private sessions. I have devised what is called the rule of exception. We tell the parties at the mediation process that we will presume that whatever you state is not confidential and can be disclosed. You tell us what should not be disclosed. That is the exception, rule of exception. We will not disclose it. The same principle can be adopted in the ODR process. As Colin pointed out, we tell the parties the information is in public domain unless you specify otherwise. I don't know whether I made any sense, Colin. Have I?
Absolutely. Absolutely, you have. Eminent sense. Eminent sense.
Okay. So.
I'm so sorry to do this, my friends, but I think I'm going to need to actually opt out here. I need to step away. It's getting quite late here in California. But I know you're in capable hands with Mr. Shivkumar in terms of answering further questions. But I want to please.
So yeah, Colin. But before you take a goodbye from us, just to introduce one of our very senior international arbitrator and mediator, Mr. JLN Murthy. He's a member advisory board for our e-mediation writing. So we welcome you, Mr. Murthy, sir. Thank you so much for gracing this occasion. And Colin, thank you again. Thank you so much for being part of this wonderful August moment. And we'll keep you we'll bother you again and again for this classroom series.
Please do. Please do.
I'll share with you the components of the course content. And if you can help us build up those topics, it would be a delight for law students of India. So thank you, dear. Thank you once again. And on behalf of everyone at e-mediation writing, you are part of this family, and we love to have you again and again with us. Thank you so much.
Thank you so much. Thank you so much, everyone. Please.
So much.
Yes, take care, and we will talk again soon. Okay.
Thank you. God bless. Thank you.
Goodbye.
Bye. Bye. So, Sarsh, you can take on those questions. We have Mr. Shivkumar sir with us. Please,
Yes,
please
ma'am.
take on.
Yes, ma'am. Sir, there is this question in the chat box by Miss Anisha Sondhi. Sir, ma'am's question is this, that whether it's the fundamental resistance of the human to change or the resistance of the system and the people who compose it for the ODR platform to cherish in the ongoing period.
Where is this question? Let me, is it on my screen? Anisha Sondhi, is it? Sorry, I can't hear you.
Yes, sir. Sarsh, tell, this is Anisha's?
Yes, ma'am. And she has also posted an example of the
Okay.
mediator's unwillingness towards mediation proceedings and their nature towards adversarial model of following the court system. So, sir, she's asking that the resistance is in the system and the people who compose it, or is the resistance
No,
eternal?
I'm trying to find that question so that I can read it during
So
the intro.
you have to
Sir,
go just, yeah. Anisha, you can
have-
come on screen and ask. Please just switch on your camera if you can.
Sir, I have put it in your chat box now.
Yes,
Yeah.
sir.
Welcome, Anisha. Yes.
Hello, everybody. So my question is that during my internship at the mediation center, I observed a trend that a lot of lawyers, they try to dissuade the clients that you don't need to answer the questions, you don't need to you stick to your ground, and that this proceeding is not binding, and that we'll go to the court anyway. So they try to dissuade the clients, they don't let them speak out. So how does a mediator deal with such situations?
Let's put it differently. Such a situation can arise out of two reasons. Fundamentally, a mediator has failed to explain the process adequately to the parties. And once there is the lack of explanation and a clear understanding of the process, this would be the reaction. Therefore, there is a fault in the mediator who refuses to explain in detail how the process works. Perhaps the mediator has not conveyed to the parties concerned that you can go away from mediation whenever you want. They see it as a compulsion. That's one reason. Most often that is the reason. The second is probably the lawyers have not understood the process themselves. I suspect these are lawyers who are youngsters, who are juniors, who are 1 year old, 2 years old in the seniors' offices, who are sent for mediation without any clue about what the mediation process is. And therefore, their concept is, I have to protect my seniors' interests. I have to protect my officer's interests, which translates into revenue generation. So there is misconception. And if a mediator has failed to do this duty, then I'm afraid it reflects poorly on the quality of the mediator. The third possibility is that young advocates have to be trained in or sensitized to what mediation is about, what ADR is about. And that's another area where we need to work on. I agree with you. Your questions are completely relevant. There's nothing irrelevant about it. And we are in the process of constantly trying to reinforce amongst the mediators and among the advocates that this is not adversarial, that mediation does not work contrary to or in contradiction to or in conflict with the regular process. It is supplementary, it is complementary. So that's the best answer I can give you right now. I don't know whether you're satisfied with the answer. If not, please
No,
tell
sir.
me.
Definitely, sir. I agree with you. I agree.
Thank you, sir. Sir, we have another question in the chat box. Would you like to, sir, should I speak it or would you read it?
Where? Which one? If you could please tell me.
Sir, it is from Dirgha Nanavati, madam.
Okay.
It is above Anisha's ma'am's question.
Yes. You can read it out for the benefit of everybody.
Sir, yes, sir. So the question is that how is it that we can accelerate the process of introduction of ODR in India? It can be done through cooperative practices, through a convention, or through reflective legislations. So the question is that what would be the most appropriate way to introduce and develop ODR in India?
As I pointed out to you, the Niti Udyog is already in the process of setting down a policy and setting up methodologies for introduction of ODR in India. The preliminary report is already in our hands. We have submitted several suggestions to it and the process is on. So you will find something happening in that field in the near future. The larger question I would like you students to think about is, can legislation replace ethical standards? Now you're saying, how do we accelerate the process of introduction of ODR in India? By way of cooperative practices, which take the form of a convention and then reflective legislation, etc. Legislation is not an answer to human behavior. Please get this very clear. Legislation can control the mechanism, but ADRs and ODRs are dependent upon the individual person who runs these processes. If you have a mediator sitting in at one end of an online dispute resolution process and the party on the other side, the ethical standards that the mediator must follow are critical. So irrespective of legislation, we need to concentrate, I think, on quality, on ethical standards, and training a set of mediators who are above all these temptations of daily life. I'm being very, very frank. Legislation will be required. It is on the way. Maybe another 3-4 months, you'll have a legislation comprehensively on ADR, ODR, and mediation, and so on and so forth. Does that give you some insight, Dirga?
Yes, sir. Yes, sir. Thank you, sir.
So any other question we have? Sir, do we have any more?
No, ma'am, we don't have any more questions.
Okay. So, Mr. Murthy, sir. Mr. Murthy, sir.
Yes, madam.
Can you please share your words on today's topic and some blessings, if you can give it to the students who are here with us, a message?
It was wonderful to listen Shivkumar sir and others today, and I feel that this kind of a webinars very specifically for the students' wings, because being suggested by the Honorable Chief Justice of India to have as a bar as a curriculum in the regular law schools, and also the Bar Council of India is accepted to that. I understand this kind of a programs will give you more skills in the mediation side, not only the classroom teaching, but I think many more doubts with the for the student wings, and also to understand the latest update on the mediation will really help the student wings very specifically, and not only the students wings, but also to us also to learn many things in this. I thank you, AMW, for giving me an opportunity, and I also thank Shivkumar sir also and others, those who have spoken today. Thank you very much.
Thank you, sir. Thank you, sir. Shiv sir, last words from you for the topic of the day and for our students, and even for us. We, the mediators from this family, would love to have some message from you. It will be of great importance.
Take just 2 minutes, if you don't mind.
Please,
there is a very nice comment made by Mr. Tankachan, the king of technology. I think that is the message for all of us. As rightly said, we are not ready for the change. Inertia is a basic human nature. We are very much anxious about the future. Only those who are ready to face challenges can do things differently and make this world a better one.
Correct.
Let's translate this into a very basic fundamental principle of mediation, which all of you will ultimately learn and have to be acquainted with. It's a very one-line principle. Please understand and accept that this also is, rather than this ought to be, a core principle of mediation. So when I say that I am not willing to change, what I am saying is this is what ought to be.
Correct.
But when I say that I'm willing to look at something different, I'm saying this also is.
Correct. Very
So,
true, sir.
That is the message I would like to give to. Yes.
Great lesson in this message. Thank you so much, Mr. Thankachan, sir. Thank you so much. Rather, you can unmute yourself and just share your words with the students. They would love to hear it from you, sir.
Now, 1 minute before Mr. Thankachan, all the students, I don't know how many there are, do not be disheartened by these challenges, please. The way you lose a case in court because of a bad judge doesn't make you walk away from the profession. What you say is, I will try better next time and convince the same judge that I have a better case. So these challenges are steps to learning. There's no point in saying, oh no, I don't think I can do this. This is not working the way I want it to work. Therefore, I will walk away. No, that is a defeatist attitude. It will not work in the profession, either as a lawyer or as a mediator or as a conciliator. Yeah. I mean, I know I sound very, very patronizing, but having had 50 years at the bar, I finished 49 years of practice. This is all I can say to you. Enjoy your success as much as your failure. That's it.
Correct, correct. That equally applies to us also in this age, sir. Not just for the generation next, but to us also.
Great word.
Mr. Thankanjan, sir, uh, can we hear from you also?
Dear Shiv sir, dear Pushp ma'am, dear Muki sir, and my dear young friends, it's a wonderful opportunity for you. Say, we started our program. It's a small beginning, but I hope it will become a history in the future.
Some network issue at your end, I think.
No, he's frozen. His image is.
Some network issue at your end, sir. Sir, may I please take on then, Mr. Thankanjan, sir? No, he's unable to. So students, can you please just switch on your cameras if we can have a group photograph of our class? Let's have it captured in our camera. Yes, please just switch on your camera and we can have a photograph also. And then my request to each one of you that it's just a beginning today and our classes would be starting from 2nd of January and we'll share a complete timetable with you. And the components which are there in BCI curriculum, it's prescribed by them for 9 to 14 weeks. So we'll make it more practical for you, not theoretical, but a practical exercise. When you come out and when you just finish with this course, you'll definitely be a better person. You'll be a better legal advisor. You'll be a better advocate. So please ask your friends. It's a pro bono initiative from Pan India Mediators and Trainers. You would really love this program, this classroom. We promise you that. So get your enrollments done from 2nd January, online classes from the best mediators and trainers of this country. And we'll have from the other parts of the globe also. So I think, Saharsh, you have shared some feedback form also. We would like to have it from you, though, that feedback so that we can improve. And your mobile numbers are here with us. We'll send you a complete timetable. And there is absolutely, it's free. Please ask your friends just 1 hour a day on every Saturday. We propose to go ahead with this. And we'll have more of role plays wherein you would be asked to participate in the exercise because a role play registers the concept well than a theoretical thing. And one thing more, our e-mediation writings, we have already started with the theory classroom series by Mr. Shiv Kumar and our very senior mediator trainer, Mr. Bharata Chakravarti. Please, kids, please do read those chapters. And our writers, Mr. Shiv Kumar, Bharata sir, they would be more than happy to have any query, any comment, any concern shared with them by you. They have their email addresses at the end of the article. Please make use of such time. You will definitely relish in times to come that you are the first batch of the online classroom series by e-mediation writings team. So be a part of history and be our ambassadors for future online course on mediation. So thank you so much. Thank you, Mr. Shiv Kumar sir. Thank you so much for this valuable and our dear family friends from EMW, everyone. Jyoti, I can see Kavita is there, Rajesh is there, Anup was there, Neena ji. Sorry if I'm missing from screen. Rohit, Arkidus, we have them here. So thank you so much once again. Punita was here. I think she was here with us. Sandhya was there.
Hi.
Yeah. Thank you so much, everyone, for being here with us. And of all the people, a special thanks to Anupam Sangi, our very dear friend, energetic friend, for this moment to take forward with Saharsh Pandey, and we have Aditi Aditi also, who is looking after ADR in NLUI Maharashtra. So Aditi is going to just team up with Saharsh and Anupam to take this moment further, and we'll have more students enrolled for this experience. We will not be ragging you at all. There will be no ragging in this class. It will be absolutely fun loving. So Sanya, I can see you there in the camera. welcome. So thank you again.
Thank you, ma'am.
Anything else you would like to share? You're most welcome. And 2nd January, we are meeting again, kids. Thank you so much. Thank you, sir. Thank you, Anupam. Thank you, Mr.
Thank
Murthy,
you,
sir.
everyone.
Thank you so much.
I think
Thank you, Mr.
Pushp
Shivkumar,
has
sir. Thank you,
really
thank you.
started a great initiative, and it definitely resonates very, very high energy. So I wish all of us very, very collaborative and great time together. Thank you so much, Pushp. And
Thank you so
Shivkumar,
much.
sir.
Thank you, everyone. Thank you.
Bye.
Looking forward to see you. Thank you.
Thank you,
Thank you,
ma'am.
Tangachan. Bye-bye.
Bye. Thank you, Mr.
Bye.
Thankanjan. Thank you. Thank you. Bye-bye.